Was the spying on the Trump campaign in 2016 adequately predicated? That's for Attorney General William Barr to decide. Hello, this is Robert Romano, Vice President of Public Policy with Americans for Limited Government, dailytorch.com. Hit that subscribe button. Today we're going to be talking about Attorney General William Barr and the Inspector General of the Justice Department, Michael Horowitz, who is expected to release a report to the Attorney General. It'll be published publicly on December 9th. And then he'll be in to testify before the Senate Judiciary Committee on December 11th. And while initial reports had suggested that the Inspector General report would include criminal referrals, including for an FBI official under investigation after allegedly altering a document, more recent reports, particularly from the New York Times, have cast doubt on whether there's going to be any finding of inappropriate spying by the Justice Department on the Trump campaign. According to the New York Times report, in fact, it will contain a conclusion, quote, by the department's Inspector General that the FBI had a sufficient information to open the investigation into whether any Trump campaign associates conspired with Russia during the 2016 presidential race. Now, both things can be true. That is, that there were some crimes committed by agents pursuing false allegations against the Trump and campaign and President Trump that they were Russian agents, and that the Inspector General is concluding that those crimes would have not altered the FISA court's decision to approve the surveillance in the first place, or the FBI's decision to initiate the investigation. So there's a little bit to unpack here. The allegations against President Trump and his campaign originated from the DNC and Hillary Clinton financed Christopher Steele dossier. He was a former British spy. They fed this information to the campaign and then to the FBI and the Justice Department. It resulted in basically surveillance of the Trump campaign, unprecedented access to campaign phone calls, emails, text messages, and other documents that began in October of 2016. Ultimately, this led to almost a 3 years long investigation, 2 years of which were led by Special Counsel Robert Mueller, who ultimately found that there was no conspiracy between Trump and Russia, nor in his campaign. And we need to find out what then, therefore, was the basis for this. On April 10th, Barr testified to Congress before the Senate Appropriations Subcommittee for the Justice Department's budget. And he said that, quote, I think spying did occur, but the question is whether it was adequately predicated. I think spying on a political campaign is a big deal. It's a big deal. The generation I grew up in, which was the Vietnam War period, people were all concerned about spying on anti-war people and so forth by the government. And there were a lot of rules put in place to make sure that there's an adequate basis before our law enforcement agencies get involved in political surveillance. I'm not suggesting those rules were violated, but I think it's important to look at that. Later in his testimony, he would couch his description of the spying and what he would be reviewing, saying, quote, I want to make sure there was no unauthorized surveillance. Now, that's a real key term there, unauthorized surveillance or authorized. When did the surveillance really begin? In the October 2016 FISA warrant? In July, when agents began following the trail of breadcrumbs left by Trump's political opponents, or earlier? As far as whether it was fully authorized, we know it was because there was a FISA warrant that began in October 2016, approved by the FISA court. So it's fully authorized. Was it adequately predicated? I think that's a separate question. Just because the FISA court rubber stamps these applications by the FBI and the Justice Department doesn't mean that they're adequately predicated. It can mean that the guidelines for obtaining such a warrant are too minimal. And I think that's what happened here. Was it adequately predicated? On that question, again, the Mueller report, I think, gives you the answer to it. Mueller's already told us the answer. Quote, the investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities. And, quote, the evidence does not establish that the president was involved in an underlying crime related to Russian election interference, that included all members of the campaign. Per Mueller, quote, the office did not find evidence likely to prove beyond a reasonable doubt that campaign officials such as Paul Manafort, George Papadopoulos, and Carter Page acted as agents of the Russian government or at its direction, control, or request during the relevant time period. And then as for former Trump attorney Michael Cohen, he was said by the Steele dossier to have traveled to Prague and met with Russian agents. Well, according to Mueller, Cohen had never traveled to Prague. And that discredited a key allegation from the Steele dossier, all of which raised the question, if in the end there was not enough evidence to, on a probable cause basis to bring indictments of Trump campaign officials or Trump himself on being Russian agents, then what was the probable cause for obtaining the Foreign Intelligence Surveillance Act warrant back in October of 2016? If there's not evidence to prosecute, why is there evidence to spy? I think shouldn't that be the same thing? You're supposed to have a basic Fourth Amendment protection that no warrant shall issue but upon probable cause that a crime has been committed. Now, again, this was the same dossier, these allegations by Christopher Steele that Trump and his campaign helped hack the DNC and John Podesta emails and put them onto WikiLeaks. Well, James Comey, former FBI director, he had called the same dossier information in January of 2017, quote, salacious and unverified, and yet it was used by the FISA application. And we know that from the FISA application itself. If you read some of the footnotes, it says, quote, U.S.-based law firm that had hired the identified U.S. person to conduct research regarding candidate one's ties to Russia, and that refers to the DNC law firm Perkins Coie, who hired Fusion GPS, who contacted Christopher Steele to gather the information on President Trump. Then candidate Trump, quote, the FBI speculates that the identified U.S. person was likely looking for information that could be used to discredit candidate one's campaign. To me, and this is from the FISA warrant application, this is the Justice Department admitting that they knew it was political gossip. I think it's the most damning statement in the 2016 FISA application. The FBI admits it knew it was gossip all along, and they went ahead and spied on a presidential campaign, the opposition party, in an election year just a few weeks before people were voting, and was all based on Steele's allegations. He said, quote, there was a well-developed conspiracy of cooperation, quote, between then candidate Trump and Russia, and that started in July of 2016. This was managed on the Trump side by the Republican campaign manager Paul Manafort, who was using foreign policy advisor Carter Page and others as intermediaries. The two sides had a mutual interest in defeating Democratic presidential candidate Hillary Clinton, whom President Putin apparently both hated and feared. Inter alia, source E acknowledged that the Russian regime was behind the recent leak of embarrassing email messages emanating from the Democratic National Committee to the WikiLeaks platform. The reason for using WikiLeaks was plausible deniability, and the operation had been conducted with the full knowledge and support of Trump and senior members of his campaign team. But when Steele had to go testify in a court about this, then they asked him about the information. Did it need to be corroborated and verified? When he had handed it off, he said it needed to be, quote, further corroborated and verified, meaning that it wasn't fully vetted even by Steele himself, and he knew it. And so this was a red flag that should have been raised. Now, he said that all of it contained a material risk of being disinformation. So, and further, we know that Steele didn't go to Russia himself and was said to have relied on a network to relay the information, stating that the allegations needed to be further corroborated and verified. And he cited a bunch of sources. And source A was a former top Russian intelligence officer. Source B was a senior Russian foreign ministry figure. Source C was a senior Russian financial official. And source G was a senior Kremlin official. But Steele's subsources must have been several layers removed, as we learned later that Steele never went to Russia himself, according to Senate Intelligence Committee testimony from Glenn Simpson. He's the head of Fusion GPS. And according to Glenn Simpson, that Christopher Steele, he hired, quote, a network of sources who lived in or came from the place that you're interested in, who can travel and talk to people and find out what's going on to get the dirt. But we don't know who, since per Simpson, quote, I didn't ask for the specific identities of specific people on why Steele didn't go to Russia himself. Simpson said, quote, he really would not be safe to, if he went to Russia. He's been exposed as a former undercover British intelligence officer who worked in Moscow, so it wouldn't be wise for him to go into Russia. From the FISA warrant application itself, the FBI and the Justice Department were aware of the fact that this was not firsthand information from Steele. Quote, Source 1 tasked his subsources to collect the requisite information, and Source 1 received information from the subsources described herein. Source 1 provided the information to the identified U.S. person, that was Glenn Simpson, Fusion GPS, who had hired Source 1, and to the FBI. A March 2017 Vanity Fair piece about Steele by Howard Bloom actually gives you a full, a kind of a bigger picture of who Steele was and how he worked with his sources in gathering this information, all from where he was sitting in London. How Christopher Steele compiled his explosive Trump-Russia dossier. Quote, Steele could count on an army of sources whose loyalty and information he had bought and paid for over the years. There was no safe way he could return to Russia to do the actual digging. The vengeful FSB would be watching him closely, but no doubt he had a working relationship with knowledgeable sources, contacts in London and elsewhere in the West, from angry emigres to wheeling and dealing oligarchs, always eager to curry favor with a man with ties to the Secret Service, to political dissidents with well-honed axes to grind. And perhaps most promising of all, he had access to the network of well-placed Joes, to use the jargon of his former profession. He directed from his office at London Station assets who had their eyes and ears on the ground in Russia. Now, this should have, I think, provided more of a basis for discrediting Steele to the FBI, since they knew that there were subsources. And some of whom supposedly would have spoken to the sources in question, but it appears clear that Steele himself never actually spoke directly to whatever senior Kremlin officials, foreign ministry officials, financial officials. He had go-betweens who supposedly spoke to these, and these sources very well could have been made up, and so they, even though they stand out as key figures in the dossier. For example, who told Christopher Steele's sources that Michael Cohen was in Prague in the summer of 2016? Mueller couldn't find it. The travel records didn't show it. Michael Cohen's own passport didn't show that he'd ever traveled to the Czech Republic at all in his entire life. And so there was false information in the dossier that is accredited to these sources, who now have been debunked. And then the FBI and the Justice Department, they just kept on going ahead with these with this witch hunt on and on. On April 20, 2019, the New York Times, Scott Shane, Adam Goldman, and Matthew Rosenberg, they reported that in January 2017, the FBI had interviewed one of the main sources for the dossier and came away with, quote, misgivings about the reliability that arose not long after the document became public in January of 2017. So BuzzFeed publishes the dossier, and suddenly everyone's asking about the sources, probably because Michael Cohen had never been to Prague. And so then the FBI said, we need to talk to the sources. And then they came away with severe misgivings, according to the Times. Quote, by January 2017, FBI agents had tracked down and interviewed one of Mr. Steele's main sources, a Russian speaker from a former Soviet republic who had spent time in the West, according to a Justice Department document, and 3 people familiar with the events who spoke on the condition of anonymity. After questioning him about where he'd gotten his information, they suspected he might have added his own interpretations to reports passed on by his sources. One of the people said, for the FBI, that made it harder to decide what to trust. Then the FBI, now they also appeared to discount the possibility that this was Russian intelligence disinformation in the Times report. Quote, FBI agents considered whether Russia had polluted the stream of intelligence, but did not give it much credence, according to the former officials. So this was a ton of red flags. By January, they had already spoken to some of the sources who said it was bad information. They should have already known that Michael Cohen had never been to Prague. They knew from the FISA application, the Justice Department was admitting to the FISA court that Steele was using hearsay. He had subsources. He wasn't a direct witness to the allegations that he was purporting. And then the FISA court, they went along with it anyway. The Justice Department has said, oh yeah, we can spy on the Trump campaign, the presidential campaign the Republicans are putting up, the opposition party in an election year. Yeah, no problem. Now, it's the worst possible outcome, though, if the Horowitz report comes up with some sort of self-serving conclusion from the Inspector General that FISA, the Foreign Intelligence Surveillance Act, was somehow not violated, even though the allegations into Trump were made by his political opponents, and even though they were false. What it says then is that FISA allows allegations of treason to be brought forward to the FISA court based upon nothing more than hearsay. And that's a terrible, terrible thing. And they need to reauthorize FISA with some more protections included, or don't reauthorize it at all. This needs to be fixed. We know, on the other hand, that the investigation by U.S. Attorney John Durham has been expanded into a criminal probe. And so this could offer some hope that perhaps there's a contradiction or disagreement in the Justice Department. Horowitz doesn't think there was a problem with the surveillance, but U.S. Attorney John Durham, he may be bringing prosecutions as a result of this surveillance. So again, both things can be true. Both of these reports can be true. And we know that Attorney General Barr is committed to getting to the bottom of what really happened in 2016 with this political surveillance that was going on. And ultimately, if there is a contradiction, if there is a disagreement in the Justice Department about whether this was illegal or not, it's up to Attorney General Barr to answer these questions. Ultimately, he has way more power than the Inspector General, who doesn't work at the Attorney General's discretion. The Inspector General, he's going to make his report, and it may include some violations or criminal referrals. He could also say that there was a sufficient basis for bringing the FISA warrants against the Trump campaign. And Barr can come back and say, no, there wasn't. And here's all this additional information that I and John Durham have been investigating, and they can bring indictments. My personal opinion is that if nobody goes to jail for basically unprecedented spying of the opposition party in an election year, people are going to lose whatever confidence they had left. Public confidence in the Justice Department already hangs by a thread. And I'll leave you with the close here. That is why here the Inspector General's opinion is interesting, but appears preliminary and not the final word on the matter, which lays with Barr. But the Attorney General needs to help out Congress here. If this spying based upon false hearsay allegations is not prohibited by FISA, then Congress needs his recommendations to make sure this doesn't happen again. Because if it needs to be included, if we need additional protections and Congress is not willing to add those, then FISA shouldn't be reauthorized. That's the commentary. This is Robert Romano, Vice President of Public Policy with Americans for Limited Government, dailytorch.com. Hit that subscribe button, ring the bell for notifications, and have a good day.